You're with the PI Show. Thanks for joining us. Now it's time for our favourite part of the program where we answer viewers' questions. So let's check out the mailbag this week with Vivian Ryan.
Thanks, Harry. Thanks, Tony. Good to see you guys. Thanks again for writing in, viewers. Don't forget, if you've got a question for us, please log on to thepishow.com. Today we've got a question from Daniel, and he writes from Ballarat. Hi, I'm a regular viewer of your show and have often heard you talk about a person being awarded money for past and future loss of income. I recently heard from a friend that there are limits on how much money can be awarded for that. What exactly is the limit? I work as an accountant, and is it possible that I will receive my full income if I got injured? This is just out of interest, but I would love to hear your response. Thanks, Daniel. Tony.
Well, Daniel, if it's a car accident or work accident, the limit's hovering around $800,000, and it depends on a lot of things. It depends on whether you're totally incapacitated for work or if you're partially incapacitated for work, and there's also discounts that apply. So in other words, they discount the money you receive by amount of 6%, and if it's an action that arises out of a public liability matter, the discount's 5%, but usually you can claim up to 3 times average weekly earnings, which after you deduct tax is probably approximately $1,800, I think. Is that what you think, Harry?
Yeah, but that's per week for both past and future economic loss. The law says they're trying to compensate you to have full compensation for future economic loss. However, that, in my view, doesn't work in practice, and most claims settle with considerable discounts. So it's an interesting question, and there are upper limits on what you can claim for your future economic loss, and in my view, the law does not compensate you fully for your future economic loss.
Well, Harry, one of the key elements is the fact that you're getting the money up front. They look at the present value of the money, so it's a bit like a mortgage going backwards when they pay you out.
There's a discount for receiving a lump sum today, but it still does not properly compensate people.
No, it's a significant reduction on what you'd really earn if it was over the course of your employment.
So best thing is, Daniel, don't have an injury, don't have an accident, keep working.
Excellent. So it doesn't really matter. He's an accountant, so it doesn't really matter what your occupation is. The upper limits are the upper limits, and
the upper limits for everyone. Yeah, it
right.
doesn't matter.
Okay, great. Thanks for the question there, Daniel. This question comes from Amy. She says, "Hi, Harry, Tony, and Viv. I work in a cafe and recently hurt my back and shoulder when I fell down the stairs. I've been unable to work for 2 weeks because it hurts to stand up for long periods of time, and I can no longer carry cakes because they are heavy." She obviously works in a bakery or something. At work, the kitchen is downstairs and the sitting area is both downstairs and upstairs. I found that I would be coming up and down the stairs quite often, and I have to walk really quickly because we are often busy. I believe the stairs are also unreasonably narrow and steep, so I can't always firmly put my foot on the step, and this is how I fell. My question is whether I could claim work cover benefits and whether I have a claim in negligence. I hope to hear from you soon. Thanks. Amy. Harry.
You can have a crack.
Tony?
Amy, you can claim work cover statutory benefits. The injury is 2 weeks old. It's back and shoulder. But the first step is fill in a claim form, put in medical certificates, and have the claim accepted by the work cover claims agent. So that's the first step. And then you should be receiving your weekly payments. 95,
no-fault benefits.
Yeah, no-fault benefits. 95% for the first 13 weeks, and then 75% thereafter. But so that should cover you in the initial period. And then the issue of negligence is an interesting one. Falling downstairs, there's again, taking photographs of the scene of an accident is terribly important. Things change, and photographs, sketches of what the stairs were like when you fell is important, possibly getting the name of any witness available. And then you've got to wait, in effect, with work cover 18 months before you can consider any common law claim. So there's a lot of things that would happen.
What would happen if she was wearing incorrect shoes? So maybe if she was wearing heels,
it could affect the claim.
It might be what's called contributory negligence. There might be an element of that, but Tony's.
The only thing I'd add to this, Viv, is that, and Harry, if the injuries were very, very severe, I'd probably get an expert to go out there, measure it up, and just have a close look at the whole staircase.
Because it could happen to
see
somebody
if it
else
complies
as
with
well,
building
too.
codes, all sorts of things, because there might be some breach of a building code. The lighting might be poor.
That might be the responsibility of the owner of the building rather than the person who's occupying it.
Once you get that report, Harry, it covers everyone. It picks up, probably the occupier, the owner, picks up everyone. So I think getting the evidence together is pretty important.
And that's if there's a potential serious injury. But it's only 2 weeks old, so...
so it's a cost-benefits analysis too. If the injuries are severe, get someone out there. Yeah.
So go and see a medical expert and a lawyer at this stage.
I think I'd get a lawyer.
Yeah. All right, our next question comes from Stephen, and he's writing from Glen Ira. He says, about 3 months ago, my sister crashed her car into a pole when she fell asleep at the wheel. She suffered broken ribs and a broken leg. We discovered that she fell asleep because of medication prescribed by our GP. Neither the GP nor the pharmacist warned us that the medication could make her drowsy. Because she works as a dance teacher, she will be out of work for a while. She also regularly auditions for roles in productions, but as yet has not been successful. I was wondering if we could sue either the GP or the pharmacist or both. Is it relevant that she will be missing out on some big auditions? Thanks in advance for your help, Stephen.
Viv, this one here, I'd get her on stat benefits first with TAC because it's no fault benefit.
It's a single car collision. So prima facie she's entitled to stat benefits.
And prima facie a case against a GP or a pharmacist appears pretty tough. But what you need to do is investigate. I think most packets of medication say...
On the side of it, whether or not...
Yeah, there's always...
Side effects.
Side effects, don't drink and drive, don't do this, don't do that. If you take this
operate
prescription...
heavy machinery
Well, if you
often.
take this prescription, don't drive or operate machinery, you know what I mean? So I think you'd need to investigate it pretty carefully. We don't know enough on the facts to be able to give a proper...
It says the GP nor the pharmacist did give her advice, but again, it's probably second-hand information that you've got. You need some pretty strong evidence,
toxicology reports, all sorts of things.
Of what was said, and also whether the drowsiness was in fact caused by the side effects of the medication. Causation is an issue in this case of what has caused her drowsiness.
Harry,
if she'd been out and about drinking or at a club for 24 hours, well, then there might be other explanations about drowsiness.
Definitely,
so
carefully.
It's a difficult case, but plaintiff lawyers always have an open mind, and we like the facts.
Right.
So
it's the end of the show again, believe it or not.
Thanks for sending in all the emails. Please have a look at the show and send in any queries you've got. Viv looks at them all, and we try and answer as many as we can. Thanks for watching, and see you next week.
Thanks, yours.
Thank you.
Thank you.
Viv, Harry.
Cut.